is stated in the Article 1263.
We'll be talking about Article 1263.
How does Article 1264 apply to our scenario?
Article 1265 stipulates that
Article 1266 states that because under Article 1267,
The given scenario is applicable to Article 1268.
According to Article 1269,
particularly the Articles 1270 and 1271.
The law provides under Article 1272,
according to Article 1273,
in reference to Article 1274,
Okay class, as usual, let's start our oral recitation. Please prepare yourselves as we start. So, the open for everyone question. What is stated in Article 1416?
Article 1416, when the agreement is not illegal per se but is merely prohibited, and the prohibition by the law is designed for the protection of the plaintiff, he may, if public policy is thereby enhanced, recover what he has paid or delivered.
In addition, Article 1416 is another exception to the rule that where both parties are in pari delicto, they will be left where they are without relief.
Correct. Ms. Pagunsa, what are the conditions for recovery to be permitted?
Recovery is permitted provided that, first, the agreement is not illegal per se, but is merely prohibited. Second, the prohibition is designed for the protection of the plaintiff. And lastly, public policy would be enhanced by allowing the plaintiff to recover what he has paid or delivered.
Right. So, according to Sections 3, 7, Article 12 of the Constitution of the Philippines, a land sold in violation of the constitutional prohibition against transfer of lands to aliens may be recovered. Can you elaborate on this, Ms. Digamo?
The Civil Code of the Philippines 7 states that real properties are governed by the law where they are situated. Necessarily, transactions involving real properties located in the Philippines must be governed by Philippine law. A general rule on pari delicto would be applied to the sale of land to aliens instead of setting the contract aside and ordering the restoration of the property. Then the public policy to conserve lands for the Filipinos would be defeated and its continued violation sanctioned.
Outstanding. How about in a home state? Does the principle of pari delicto applies?
It is not applicable to homestead, which has been illegally sold within the prohibited period of 5 years in violation of the homestead law. The policy of law is to give land to a family for home and cultivation.
Consequently, the law allows the homesteader to require the land even if it has been sold. It is not within the competence of any citizen to barter away what public policy by law seeks to preserve.
Very well said. Now, let's say M acquired land from the National Abaca and other Fibers Corporation. M leased the land to R. As the leasee failed to pay the rentals, M sued them for the rescission of the contract of lease. R, among other defenses, countered that M has no right to sue because he violated RA number 477 of the Labor Code of the Philippines. Is it possible for M to recover the land considering that he is in pari delicto with the lessees?
M may still sue for the recovery of the land. There is no provision in Republic Act No. 477 providing that the grantee automatically loses his rights over the land if he violated the law, as that the land reverts to the state. In this case, the interest of the individual outweighs the interest of the public.
Very good. Thank you so much. Now, moving on, Article 1417 states that when the price of any article or commodity is stated or determined by statute or by authority of law, any person paying any amount in excess of the amount price allowed may recover from such excess. What does this tell about the recovery of the amount paid in excess of the ceiling price? Ms. Pagunsan?
In the recovery of the amount paid in excess of the ceiling price, a statute fixing the maximum price of any article or commodity is usually known as the ceiling law. It can also be determined by authority of law as by executive order of the President. Its purpose is to curb the evils of profiteering or black marketing.
An example of which is supposed by executive order of the President, the price per kilo of rice of a particular brand and quality has been fixed at 20 peso. If a person pays 22 peso for it, he can recover the excess of 2 peso.
Excellent, class. I can see that all of you did your studies well. Now let's end our oral recitation as we proceed to our next lesson. We'll be talking about Article 1418.
In the Article 1418, when the law fixes or authorizes the fixing of the maximum number of hours of labor, and a contract is entered into whereby a laborer undertakes to work longer than the maximum thus fixed, he may demand additional compensation for service rendered beyond the time limit.
That's right, Miss Advestress. I can see that you did not only prepare for oral recitation but did advanced study as well. How about Miss Doctolero? Under Article 1418, it states that the recovery of additional compensation for service rendered beyond the time limit. What does it tell us?
Presidential Decree Number 442 as amended, otherwise known as the Labor Code, sets forth that the normal hours of work of any employee shall not exceed 8 hours a day, and the law applies to employees in all establishments and undertakings, whether for profit or not, but not to government employees. This means a person employed by the government or acting under the color of state law. Next is the managerial employees. This means an employee who by virtue of his contract of employment or his seniority in an organization may be required or permitted to hire, transfer, promote, suspend, lay off, dismiss, reward, discipline, or adjudge grievances of other employees. Next, we have the field personnel. Field personnel shall refer to non-agricultural employees who regularly perform their duties away from the principal place of business or branch office of the employer and whose actual hours of work in the field cannot be determined with reasonable certainty.
Attorney, if I may add, it also stated that the number 4, members of the family of the employers who are dependent upon him for support. Number 5, domestic helpers. Means a domestic worker is a person who works within an employer's household. Domestic helpers perform a variety of household services for an individual or a family, from providing care for children and elderly dependents to housekeeping, including cleaning and household maintenance. Number 6, persons in the personal service of another. And lastly, number 7, workers who are paid by result.
I'm impressed, Miss Doctolero and Miss Digamo. Now, Miss Sumilye, could you please give me an example to Article 1418?
Miss Samsung works in Huawei Company in Canlubang, Laguna. She works from Monday to Saturday from 8 a.m. to 5 p.m. as the maximum working hour. However, she works from Monday, Wednesday, and Friday from 8 a.m. to 7 p.m., exceeding 2 hours beyond the maximum working hours.
Excellent! So, I will now be expecting that all of you understood Article 1418. I don't even have to discuss it further. Keep up the good work, class, and we'll be ending our session here. Thank you very much, and class dismissed.
Good day again, class. So in this session, we will be having an oral recit to check if you have done your assigned readings. Patay, kinakabahan na. So just like the last time, I will be telling you a scenario and then you have to answer a question or a series of questions afterwards. So the first person for today's recit is kinsa may sulti on dirabi. Miss Delmar. Miss Delmar, are you here?
Yes, attorney. Good morning.
Okay. Miss Delmar, let's say for example, Brianna, the owner of a candy factory in Cebu, executed an employment contract with Cello as a laborer. In their contract, both of them agreed that Cello shall be paid on a weekly basis with a rate of 350 pesos per day. Again 350 pesos per day. For a few months now, Cello has been receiving this wage rate. However, she just recently found out that what she has been receiving was actually below the minimum wage, which is 435 pesos. Is she entitled to receive the deficiency, Ms. Delmar?
Yes, attorney. Cello can recover for the deficiency of 85 pesos per week with legal interest as per Article 1419 of the Civil Code.
Then what does Article 1419 say, Ms. Delmar?
Article 1419 states that when the law sets or authorizes the setting of a minimum wage for laborers and a contract is agreed upon by which the laborer accepts a lower wage, he shall be entitled to recover the deficiency.
Good. In this case, is the employer criminally liable?
Yes, attorney.
Okay, criminally liable. Now, let us take this a step further. What if you are the lawyer of Cello? What would you have her do, Ms. Delmar?
Well, attorney, I will advise her to first try and settle the matter amicably with her employer. If she is unable to do so, then I will advise her to go before the labor arbiter and file a case against her employer for non-compliance of the minimum wage law.
Good. You are done for today's recit, Ms. Delmar. Now let us have Ms. Tumandao. Are you here?
Yes, attorney.
Okay, here is the situation. Let us say Mr. Cañete sold to Ms. Manggubat his shoe and a kilo of marijuana, a prohibited drug, for 40,000 pesos. Is the contract wholly or partially void?
The contract is wholly void and unenforceable, attorney, as there is only one consideration for both the shoe and the marijuana, which is a prohibited substance.
Okay, but what if the contract was divisible, with the price of the shoe being 20,000 and the marijuana also at 20,000?
In that case, attorney, the contract is only valid as to the sale of the shoe.
What is your basis, Ms. Tumandao?
Article 1420 of the Civil Code states that in case of divisible contract, if the illegal terms, in this case the marijuana, can be separated from the legal terms, which in this case is the shoe, the latter may be enforced.
Good. How about this other example? Wala ka tanaghuman ha? Ikaw gyapoy mo answer ani, Ms. Tumandao.
Okay, attorney.
Ms. Dorothy issued one promissory note in favor of Ms. Manggubat for winning 2 games. One that was perfectly legal and another that was contrary to law. Let's say, for example, unauthorized sabong. Can the promissory note be enforced by Ms. Manggubat?
Yes, attorney. However, Ms. Manggubat holds the burden of proof to show what part of the amount is legal. Otherwise, the entire note cannot be enforced.
Very good. Now class, even though it is almost time, I have invited Attorney Mata for our recit today. Kay she insists on testing your knowledge further. Good luck, class.
Good morning again, class. It's nice to see everyone here. So this will just be very short. So let me begin with Miss Manggubat. Miss Manggubat, are you around?
Yes, attorney.
Good. So Miss Manggubat, there is this one couple named Eman and wife. Eman sold his parcel of land to his wife. Now my question is this legal?
No, attorney, that would be illegal and void. It is against the law for husband and wife to sell property to one another, so such a transaction is invalid and illegal. The prohibition was implemented to prevent third parties from entering contracts with either spouse, while depending on what they believe to be their respective assets, only to learn that those assets has actually been transferred to the other spouse.
Okay, now, what does Article 1421 mean when it says that the defense of illegality of contracts is not available to third persons whose interests are not affected? Yes, Miss Capuna?
For example, attorney, if Tress, a third person, became a creditor of Ammon before the transaction, in other words, before the sale of property between the couple, he can question the sale for the reason that his right or interest is directly affected.
Okay, if what you said is before the transaction, then what about after the transaction?
If he became a creditor after the transaction, then the defense of illegality is not available to him.
Excellent! And right on time for dismissal. Goodbye and thank you, everyone.
Hello class, we meet again, and as usual, I will check if you have done your reading assignments. So let's start with Miss Uy Mateo. Picture this situation. Okay. Gina made up a contract to Amy selling a parcel of land. But this land, however, is an illegally acquired title of land. So, later on, Amy sold the title to Rosa, and then Rosa found out that the title for said land, the parcel of land, she bought was illegally acquired. So now my question is, can Rosa sue Amy? And if not, please elaborate.
No, attorney. However, Amy and Rosa can sue Gina because she is the origin of the illegally acquired contract. The new contract between Amy and Rosa is void and inexistent. Article 1422 states that a contract which is the direct result of a previous illegal contract is also void and inexistent. From the previous contract, the illegally acquired title is void, therefore making the new contract void and inexistent, as it is a direct result of the contract between Gina and Amy.
Correct. As stated by Ms. Uy Mateo, an illegal contract is void and inexistent, and therefore cannot give rise to a valid contract. So moving forward, class, we are now tackling natural obligations. And in Article 1423, it states that obligations are either civil or natural. It also distinguishes civil obligations and natural obligations. So, how are they different from one another? Let me call on Ms. Castro.
Attorney, as stated in Article 1423, civil obligations give a right of action to compel their performance. Such obligations arise from law, contracts, quasi-contracts, delicts, and quasi-delicts. This means that they are enforceable by the court and it is based on positive law.
Okay, so Miss, you at the back, please state your name.
Bukog, attorney.
Okay, Miss Bukog, please explain what positive law means.
I believe that the positive laws are those laws which are human-made, which oblige a specific action, attorney.
Okay, Ms. Castro, please proceed.
So, natural obligations are not written or promulgated laws, but derived merely from reason and nature based on equity and natural law. However, such obligations do not grant a right of action to enforce their performance. When not fulfilled, it cannot be enforced in court as it is not a legal obligation.
In the article, it talks about voluntary fulfillment. So, what does it mean? Anyone?
So it simply means that the debtor complied with the same even if he knew that he could not have been legally forced to do so.
So, after voluntary fulfillment of the debtor, can the creditor retain what has been voluntarily fulfilled by the debtor?
Yes, attorney. The creditor can keep what the debtor has voluntarily delivered or rendered.
Okay. So, we need to remember, class, that when there is voluntary fulfillment, the debtor complied when he had not been legally forced to do so. So, the creditor can keep what has been voluntarily delivered or rendered, and the debtor can no longer recover what has been voluntarily delivered or rendered. So, let's move on to the next article. Let's have Miss Uy Mateo again for this one. So we have Salt and Pepper. Salt owes Pepper money that amounts to 15,000 pesos under a written contract. Now, 10 years have passed, but Salt has yet to pay the owed amount. But But Pepper chooses not to take the necessary legal actions. So in good conscience, Salt voluntarily pays the debt. The question is, does Salt have the right to recover the amount?
No, attorney. Salt is no longer able to recover the amount once he voluntarily pays, as it is his moral duty to pay his debt.
So why is it seen as a voluntary action if the case expressly states that the debt was a written contract?
In Article 1424, it says that when a right to sue upon a civil obligation has lapsed by extinction prescription, the obligor who voluntarily performs the contract cannot recover what he has delivered or the value of the service he has rendered.
And so, what does that mean?
It provides that if an obligee fails to pursue a cause of action based on a civil obligation within the period fixed by law, the obligation is extinguished. It cannot be enforced in court anymore and has become a stale claim.
Ms. Bukog, do you agree with this?
Yes, attorney, I do agree with it. The stale claim is a product of prescription, and in this case, it is a extinctive prescription, which means that the right of Pepper to take action, a legal action, is lost due to the lapse of time.
It is good, class, that all of you have done your readings for today, and I hope to see this consistency once again in our future sessions. Class dismissed.
Okay, class, please settle down. So last meeting, I mentioned that we will have another oral recitation today to check if you were able to fully comprehend and understand the readings I assigned to you. So just like last time, I will be giving you hypothetical situations and I will be asking questions afterwards. Is that understood? Okay. So let's begin with Miss Roble. So Miss Roble, for your situation, let's say Miss Yu signed a contract and purchased a pair of shoes costing 1 million pesos from Mr. Tercinio, a dealer of a big and renowned shoe company. But then, a few weeks after Miss Yu signed the contract, Mr. Tercinio realized that he cannot give the shoes to Miss Yu. And he then decided to ask his friend Mr. Castillo to fulfill the obligation for him to be reimbursed at a later time. So Ms. Roble, with that said, is the contract valid?
Yes, attorney, because even if the debtor's responsibility to the creditor has been paid in full, a new obligation now exists between the debtor and the third party. In this situation, another obligation arises between Mr. Tercinio and Ms. Del Castillo.
Okay, well said, Ms. Roble. But what if we put it this way? What if Ms. Del Castillo decided to give the pair of shoes to Miss Yu without the knowledge of Mr. Tercinio, and she decided to ask for reimbursement from him? Can she recover what she has paid to the creditor?
Yes, attorney, the third person can recover, but only to the extent that the payment has been beneficial to the debtor.
But what if the debtor refuses to give a reimbursement to the third party?
In this case, the obliger is no longer legally bound to pay because the action has been prescribed and the third person will have to suffer the loss.
Okay, very well said. However, can you further elaborate and support your claims?
The given scenario is covered by Article 1425, which states that when a debt is paid by a third party without the debtor's knowledge or consent, but the latter later willingly reimburses the third party, the debtor loses his right to sue for the amount that was paid. In this case, Mr. Tercinio reimbursed Ms. Del Castillo. Therefore, he can no longer recover what he has paid.
Okay, let me just add to what Ms. Roble has stated. So Article 1425 states that when without the knowledge or against the will of the debtor, a third person pays a debt which the obligor is not legally bound to pay because the action thereon has prescribed, but the debtor voluntarily reimburses the third person, the obligor cannot recover what he has paid. So basically, Whenever a third person pays a debt without the knowledge of the debtor may opt to reimburse the third person for paying the debt on his behalf. However, if he changes his mind regarding the reimbursement, he can no longer recover what he has paid to the third person, as it is not allowed by law. So is that understood, everyone? Okay. Thank you for your participation, Ms. Roble. You may now take a seat. Now let us proceed to Ms. Mendoza. So Ms. Mendoza, for your situation, let's say Daryl is a 17-year-old college student who sold his car for 100,000 pesos to Emerald, a 21-year-old. But then, he did not tell his parents about the said agreement between him and Emerald. And then, he lost 30,000 pesos to a thief, although he was able to deposit the remaining 70,000 in a bank. So when the contract was annulled, Daryl only returned 70,000 pesos to the creditor. So Ms. Mendoza, is the contract still valid?
Yes, attorney. Since Daryl is a minor, he is not obliged to make any restitution except insofar as he has been benefited by the thing or price received by him.
Does paying to the creditor still stand if he wants to reimburse the whole 100,000 pesos?
Yes, attorney, because the debtor still has the natural obligation to return the 100,000. So if he voluntarily returns the amount, there is no right to demand the same.
So if he is just a minor, why is there still a natural obligation to return the 100,000 pesos?
It is because the law considers that although even of such young age, a minor has already the conscious idea of what is morally just and unjust.
So what is the basis of your claims, Ms. Mendoza?
So according to the Article 1426, it states that when a minor between 18 and 21 years of age who has entered into a contract without the consent of the parent or guardian, after the annulment of the contract voluntarily returns the whole thing or price received, notwithstanding the fact that he has not been benefited thereby, there is no right to demand the thing or price thus returned. So with that in mind, Daryl or the minor is not obliged to make any restitution when the contract is annulled. However, it is to the extent that he has been benefited by the thing received by him.
So does this provision apply to all cases where minors would enter into contracts?
No, attorney. The provision only applies if a minor has entered into a contract without the consent or knowledge of their parents or guardians.
Okay, so it seems like you all did your reading assignments. I would like to thank the class for their participation during the discussion. Class dismissed. See you next meeting.
Good morning, class. I have discussed in my last session that your grades are not doing well. So you have to exert extra effort to earn extra points and pass this subject. As far as I can remember, I have given an article for each group to present and act a situational example. Shall we have Ms. Barikit's group to present Article 1427?
So a pleasant morning, attorney, and to everyone. Our group will present Article 1427. So first, what is Article 1427? Article 1427 states that when a minor between 18 and 21 years of age who has entered into a contract without the consent of the parent or guardian voluntarily pays a sum of money or delivers a fungible thing in fulfillment of the obligation, there shall be no right to recover the same thing from the obligee who has spent or consumed it in good faith. However, so long as the obligee has spent or consumed in good faith the amount of money or consumable thing voluntarily paid or delivered by the minor, the obligee is not bound to any or to make any restitution, as the obligee shall only be held liable for damages if he is guilty of fault or bad faith at the time of spending or consumption.
So, for instance,
Isabella, a 19-year-old, voluntarily paid her sister's workmate Carmel without the consent of her parents or guardian an amount of 2,000 pesos. It is to compensate Carmel's effort in looking for a rush seller of a Taylor Swift concert ticket. Carmel, who had no idea of Isabella's age, spent the money in good faith. So, given that Isabella paid voluntarily and Carmel spent the money in good faith, she is not bound for any restitution. Had she acted in bad faith, she shall be liable for damages. But note again that this article only applies to minors between 18 and 21 years old.
What a comprehensive and a creative presentation. I hope that the other group will present creatively and comprehensively too. And because of that great presentation, I am giving your group 100 points. Now shall we have Ms. Badyang's group to present Article 1428?
Good morning, attorney, and also to our classmates. My group will present Article 1428. To begin with, let us answer the question, what is Article 1428? Article 1428 states, when after an action to enforce a civil obligation has failed, the defendant voluntarily performs the obligation, he cannot demand the return of what he has delivered or the payment of the value of the service he has rendered. When we say civil obligation, it is a legal tie which gives one party the right to enforce its performance by law. Now what happens if an action to enforce it has failed? I give you an example. For instance, Amir has a civil obligation to pay Princess a sum of 50,000 pesos as payment for the damages he caused on Princess' car after hitting it as a result of him driving under the influence. However, the action to enforce such obligation has failed. Amir has delivered the full payment to Princess without knowing that the action to enforce the obligation has failed. Upon knowing that the action to enforce has failed, he can no longer demand the return of his payment as he must be deemed to have considered his moral duty to fulfill his obligation.
What a nice presentation, you guys. I think everyone really spent a substantial amount of time and effort to provide a great presentation. And because of that great presentation too, I am also giving Ms. Badyang's group a perfect score. Class, I hope that you will not forget everything that you have learned today. Class is dismissed. See you next meeting.
Clarita, the heir, inherited from her deceased aunt a parcel of land worth 4 million pesos. A creditor came forward claiming that her aunt owed her an outstanding loan of 4,650,000 pesos. Can the creditor lawfully demand this exact amount from Clarita?
In this case, Clarita is only liable to pay as to the extent of the inheritance that she has received from the deceased person. This means that it is possible that Clarita will only pay partially given that that is the full extent of the inheritance that she received.
But what if Clarita willingly offers to pay the full credit even if it is 650,000 pesos more than the value of the land she inherited? Will the law acknowledge this as a valid payment? I will give incentives to whoever can answer this question and state the appropriate statute.
Article 1429. When a testate or intestate heir voluntarily pays a debt of the decedent exceeding the value of the property which he received by will or by the law from the estate of the deceased, the payment is valid and cannot be rescinded by the payer.
That is correct. Take note, class, that the heir's voluntary payment of the difference is somewhat like an implication of her waiver of her limited liability of the decedent's debt. Thus, this means that the 650,000 pesos cannot be rescinded even in the event that she changes her mind. Allison, a personal nurse of Hugo, was given a legacy. However, the will is deemed void for lack of the needed legal requirements. Does Allison still have the right to claim this legacy?
No, If the will is void, then that means that the legacy is also void and the deceased person is considered to have died without a will. Therefore, all of the inheritance will go to the intestate heirs, and they are not liable to pay Allison anything for the legacy since the will is considered to not have been drafted in the first place.
But what if the intestate heirs want to give Allison the legacy? Will this be deemed valid and effective?
Yes, as stipulated in Article 1430, the payment of a legacy by the intestate heir of a defective will due to the absence of the required legal formalities is declared effective and irrevocable, provided that the deceased debt has been paid in full.
Excellent, that is correct. Now, that concludes our discussion for this chapter on contracts. In our next session, I will be giving you a long exam to gauge your understanding of this topic. That's it for now. Thank you.